Hello everybody, I'm Seth Weissman and welcome to another episode of Safe Real Estate. Today we are going to talk about how to handle disputed earnest money, and there is a new provision in the GAR purchase and sale agreement that I want to make sure that all holders of earnest money are aware of. As we all know, on occasion a party will not sign a termination and release agreement. And the question for the holder is then, what do I do with this disputed earnest money? And the answer is the holder can send a 10-day letter and disperse based upon a reasonable interpretation of the contract. And what that has always meant is that the holder of the earnest money can either give the earnest money to the buyer or can give the earnest money to the seller. But on occasion, some holders of earnest money have said, I'm kind of like a judge here, and I'm going to give some of the earnest money to the buyer and some of the earnest money to the seller. And frankly, I think that exceeds the authority of the holder of the earnest money. And in this year's form, we have specifically prohibited the holder of the earnest money from dividing it in some way between the buyer and the seller. The GAR Forms Committee felt pretty strongly that that should be a decision for a judge to make if the earnest money is interpleaded into court. Now, one thing I want to make sure all holders fully understand is that if the buyer and seller on their own come to a settlement agreement regarding the disbursement of the earnest money, and the buyer and seller agree to divide it, the holder can then disperse, because all the holder is then doing is dispersing based on the written agreement of the parties. So again, the bottom line is the holder can make a reasonable interpretation to disperse the earnest money, but the holder can no longer divide the earnest money between buyer and seller. I hope this episode of Safe Real Estate has been beneficial. As always, it's great to see you. Please continue to tune in. Bye now.